We still have 1 minute to start. I guess we will wait for a couple of minutes still everyone to join us. And I would like to introduce myself during this time. My name is Evgenia Raspopova. I am moderator for today's International Day of our Forum, Intellectual Property for Future. We have 3 meetings of our IP Legal English Speaking Club today. Right now, we will have Elena Fedoruk as a speaker, and she will tell us about online business and IP protection issues. At 1 p.m., we will have Alexander Privin talking about patenting new materials worldwide in different countries, in foreign countries. And at 4 p.m., we will have Nadia Reagan talking, United States of America patent attorney, talking about IP protection, international IP protection for small and medium entities and enterprises. So this is the topic of WIPO chosen for this year, for the International Day of Intellectual Property. We are here today thanks to Intellectual Property Protection Foundation. IP Legal English Speaking Club is the project of this foundation, and the aim of our club is actually to meet and practice our IP legal English. We have some communities which help us to practice legal English. We actually, most of us, I think, we use legal English while communicating with our colleagues and partners worldwide, but IP area is really not covered. And the goal of our meetings is to help colleagues, IP lawyers, professionals, just people who are interested in this area to practice English in this specific area. We are going to talk about IP protection in general. We are going to talk about patenting. We are going to talk about registration and enforcement of IP rights. So everyone is welcome. The only rule today is we do not speak Russian or any other languages except for English. So I'm still accepting our participants. And I think just one more note about some safety. If something goes wrong with our Zoom conference, we just stop the conference and please re-enter using the same link. Just one point here. Please use chat to ask questions, I think, throughout the demonstration and after. And I think after the presentation is over, we can also turn on the sound and talk if it's convenient for you. Maybe we can ask Elena some questions. So we welcome communication in any ways which is comfortable for you. Okay, so I think that's it for now, for the beginning. I'm now passing the word to Elena. Please introduce yourself and we are ready to start. Thank you.
Hi. It's not easy, especially because of Alexander Privin is here. I'm so excited and I'm so worried about it. Please don't
Could I disappear?
No, don't be so strict. It's the only one. My question for you, my wish. So today we're speaking about online business and IP protection issues, and there are 3 main topics I want to discuss with you. You can see them on your on this slide at the slide. Copyright in online projects, The second topic of our discussion will be what entrepreneurs forget about in their relations with contractors. And third is liability for copyright violations in advertising. If it is interesting for you, so please use chat and write there some words about it. If it's not interesting too, please write. Please communicate. So it will be easier for me to answer your questions, and it will be more interesting, I think, about it. And of course, we will also talk about the judicial practice on the protection of intellectual property. At the end of my speech, it will be a small case session on legal disputes. So let me introduce myself. My name is Елена Федорук. I'm online business lawyer. My practical experience is 19 years now. My clients include even people from Wikipedia and the Forbes list. Here is some more information about me. And I also want to say that I'm very easy to find on the internet. Just type in Russian lawyer for online schools, and in the top 3, not counting advertising, you will see links on my sites and social media accounts. My big mission is to make online business safe and secure. That's why I cooperate with leaders of educational technologies in Russia and abroad, and constantly improve my legal knowledge in addition to my own case practice. And now I'm currently conducting a dissertation research about artificial intelligence in online business. So what do you need to know about copyright in online business? Entrepreneurs are very busy people, and if to be honest, they have no time to deal with the protection of an inclusive right, as well as protection of these rights if these rights are violated. As for judicial protection, the terms of litigation here in Russia start from six months and can reach up to 2 years and even longer. At the same time, the practice of awarding compensation is such that the court can limit it itself to only a few tens of thousands of rubles. In my practice, in my own practice, the largest refund was in the amount of 500,000 rubles. It's not too big. At the end of my speech, there will be a case session, and I will share this practice with you, and you will see more amounts of compensations. So, as for copyright in online projects, there are several problems here which I want to talk about. You can see them on this slide. First, it's difficult to agree on the transfer of the exclusive right under the contract. It's very difficult for entrepreneurs. It's easy for lawyers, but it's difficult to entrepreneurs. Second, the producer assigns authorships. The producer claims authorship, and I'll tell you how it happens. Third, problems with the transfer of rights from contractors or from customers. It's also one of the biggest problems. Then it's difficult to ensure the protection of courses, especially of the online courses, to prove that the exclusive right is transferred to the use of ownership. Then it will be interesting cases about nurse authors, money makers, and of course about dissemination of information by recipients. And now let's talk about each of these problems in more detail. One of the biggest problem is problem with copyright transfer. Entrepreneurs don't know how to transfer copyrights. There are many types of contracts, and they depends on whether the work is created or not, where the rights are constantly, permanently transferred, or for only a time. And you can see several articles of our civil code that can be used for contracts, and that's not all types of contract. And of course, we can usually it's made by me and my team. We create a combined contract, which in addition to the exclusive rights to the work, will settle other issues. For example, what services the author use for online courses, will provide in an online school, and whose expense the creation of the work will be carried out. For example, who pays for studio rent and video editing, and many other issues. Freedom of contract is an international legal principle which is also enshrined in Russian legislation. Article 421 is my favorite article. I think that you understand that we can make definitely any contract in frames of our legislation. The second problem, the producer assigns partial authorship. And here, what does the producer tell to expert to author? I gave to you a presentation template. I made edits. This was my idea at all. I gave you a methodist, and you got many knowledges from me. That's why I'm your co-author. But I have to remind you that the idea of Gogol's inspector, revisor, belonged to Pushkin. And we know that the only one author the inspector has, and it's Gogol. Then, if you come to masterclass and to learn how to make a stand from acrylic glass and or another craft, you will be the author of that craft and not the person who showed you how to do it. If it's your creative work and author created the product, not the one who gave you a presentation template or made comments on what you describe in this presentation is author of your product. And it's hard to explain to producers such easy things, but it's a really problem. As for problems with the transfer of rights from contractors or from customers, the contract is our everything. It's the main idea. There can only be one recipe, contract. And contract that defines how possible problems will be solved. That's what, at first glance, it's necessary to provide in contracts. The customer is responsible for the materials provided by the customer. If, for example, you make production for advertisement and customer gives you some pictures, so the customer will be responsible for a violation of exclusive rights if it will happen. Then sources of materials used by the artist. Creative Commons Zero, it's the one license which can be used by the contract, and it will be restrict conductors to make advertising in frames of legislation. Tracking by the contractor of the rules of advertising platform also can be included to the contract. Sanctions in case of blocking or loss of the promotion office, its cabinet, and so on. So one more time, the contract is our everything, and we should remember, and it's also difficult to persuade entrepreneurs in this, but it's true. I think you will agree with me. The next problem is it's difficult to ensure the protection of the courses to prove that the exclusive right is transferred to the use of ownership. When we write to the information intermediary for copyright infringement, we give them some documents, and it will be our contract with the author, in which it is said that the author gave us exclusive rights. But Yandex, anytime Google, many other intermediary, they say, we're not sure, you didn't sign it yourself. We only accept a notarized power of attorney, and so on. But when contacting the appropriate intermediates, if the copyright holder is not the author, it is very difficult to prove their authority. But we should remember that we have the article 1253.1 of the Civil Code, and this article establishes the responsibility of information intermediary for copyright infringement, and we should use this article. And what is the recipe? Write directly on behalf of the author. If your business partner trusts you, it is very easy to attach a copy of his passport, for example, and write requests for copyright protection as if you are the author. In Russia is one of the best methods, because they really don't believe, and they say they write, we're not sure if you didn't sign the contract yourself. Next problem, nervous authors. What I mean, these people claim, I'm the author, my method is patented, but it's not true. This is my author's course. They demand prove your authorship first. However, the method doesn't have protectability either, as well as ideas and concepts. For example, there is the author of the method of placement, Hellinger's placements, which is done with the help of coins. She is the woman who used coins for placements. And this woman writes to all psychologists who use the Hellinger's placement method that only she has the right to make coin placements, although she doesn't have any patented technique. In such situations, I recommend you to shift your focus from your own exclusion of guilt to the plaintiff's proof of authorship. For example, in 2020, in some courts, it wasn't one court of St. Petersburg, twice awarded the plaintiff monetary compensation for illegal use of city's panorama plan. Mr. Sergeyenko, whose authorship was disputed and he lost several cases a few years ago, his authorship is not proved. But this year, Sergeyenko won disputes for a total of 400,000 rubles. On 19th of October 2020, the court found it illegal to post on the internet on a site with the domain name Texiconcord.ru images of the panoramic plan of the city of St. Petersburg, the whole city, and collected 150,000 rubles in favor of the plaintiff. Then, on 13th of October 2020, from the site galernes.ru, using the panorama of St. Petersburg, the whole city of 1992, the author Sergeyenko, the court sought compensation for copyright infringement in amount of 250,000 rubles. And none of these cases did the defendants challenge the authorship, but defended themselves and justified themselves. They say that we took that panoramic plan from open sources. We are such good boys and girls, but no one of them made just a second. Made it a doubt that Sergeyenko is the really author of this panoramic plan. Cool. Then, who are money makers? People who make money on intellectual property. We have already talked about one of them, Mr. Sergeyenko, with his plan panorama. There are photographers who post their photos in open sources and then file claims against those who use such photos. These photographers do not always win, but they often manage to sue good sums, especially those photographers who live in Crimea. In summer, they shoot, they take photos, and in winter, they claim to court. Then, some organizations have gone even further. I have in my hands right now a claim from a firm, the Eighth Commandment. Here it is. The Eighth Commandment to your time is don't steal. So this organization specializes in trust management and copyright protection. It deals with the conclusion of contracts for the trust management of intellectual property objects. Most often, these are photos, after which it searches for which sites use the photos, writes pre-trial claims, and participates in lawsuits. You can find more information about the Eighth Commandment in the internet. And you probably know that before there were only well-known patent trolls. And now I don't know what to call such organizations. Copyright trolls. why do I have this claim, pre-trial claim? Because one of my clients used the photo of the photographer who trusted his copyright management to this 8th commandment, but my client, she went to notary in 2017, and it's the proof that she took the photo from open source, and there was a license in which it was clearly said that all pictures here in our site are used by under CC0, Creative Commons 0, under this license. That's why, of course, we wrote the answer that we are not guilty. Go away and don't disturb us. Okay, copyright trolls, I think it can be used in your practice also. So they make money on intellectual property. Then, who do I call missionaries? Students, subscribers, colleagues, competitors, brand advocates. Perhaps these people completely unknowingly can violate copyright by sharing their discoveries and knowledge gained from the author. For example, if we talk about the author of online courses, it's very important for them that people who purchase the course use it only for the personal purposes and do not create other products based on this course, on the course of those authors. This must be specified in the contract of the public offer. Sometimes people write, I was inspired by your course and I decided to create my own course on the same topic. Or they don't even write, but simply take and create a competing product. Is it fair? What do you think? As we remember, and we talked about it above, methods, ideas, and concepts are not protected and are not subject to protection. Therefore, the vast majority of disputes on the proof of borrowing methods are losing. One of the most striking, the case of 2012 about the system of facial renovation, it was called Revitonica. One girl created a facial massage system that made the skin more toned, more young. Another girl watched the video of the first girl and created almost the same system and called it also Revitonica. The first, of course, was outraged and went to the court in search of justice. And they passed 4 instances and couldn't prove that the second girl used her methods. In the case, an expert examination was conducted, which concluded that the movements in the first video and the second video are similar. There are 2 videos of facial massages who are similar, but the expert could not answer the question that the first video was the basis for the second. And it was a very, very pity that girls lost all 4 instances. What should I say? We have considered these main problems, and there are definitely only the main problems. And I want to say that it is the contract about the contract that it's a magic wand for online entrepreneurs, which can save many thousands and millions of rubles. It is in contract that you can provide for the transfer of copyright ownership or transfer for temporary use. And then there will be no desire to demand something in the court. But there is another interesting, so I have, I think, one question, one message. Information immediate, Yandex, Google, etc. So it's not a question. If you have a question, you can write it, not wait for the end of my speech, just write it right now, and I will know that you understand all I speak, or what should I do that it should be clear. Okay, as for contract, one more time, it's a magic wand. But there is another interesting issue for business, is liability for copyright. There is another interesting issue in online business, which, on the other hand, concerns liability for possible copyright violations, and on the other related to advertising, without which, as we know, it's not impossible to exist and develop in online space. The advertising is the engine for trade. Who said that phrase? Responsibility for copyright violations in advertising. Article 38 of the Federal Law on Advertising clearly delineates the responsibility for illegal advertising depending on whose actions caused such a violation. There are 3 members, and the advertiser, and advertising distributor, and advertising manufacturer, those who creates the advertising. So the advertiser, the person or organization that places the ad, is responsible for the largest set of violations, almost everything related to illegal advertising. An advertising distributor is a platform where advertisements are placed, a website, a social network, an online search engine. Again, it bears broad responsibility, since it is responsible for all advertising placed on it. And the government can can find them, yes. And the advertising manufacturer, producer of advertising, is responsible for those violations his guilt in which will be proven. So if he used someone else's photos without permission, or text or images or pictures without the consent of the author of this intellectual property object, then he will be responsible for this. However, without a contract, such issues are difficult to resolve. As you know, here in Russia, it's very difficult to prove that oral contract had place to be. So most often the responsibility is not assigned to the person who actually produced the advertising with violations. Claims from author or people whose images were illegally used are always addressed to whom? To advertiser or to advertising distributor, to platform, to website, to social network. And only then, after all fines, does the advertiser or advertising distributor pass them on the ad producer, on those men who created, who manufactured this advertisement. But that's not all. Big questions from online business arise to the artificial intelligence of advertising platforms. As you know, AI, artificial intelligence, is our main satellite. Thanks to it, you are eavesdropped by Yandex Alisa and Google Voice Assistant. It demolishes the story with music to which you have no exclusive right. And yes, Facebook's AI quite distinguish between broccoli and hemp. Therefore, you will not able to post a ban either. On the other hand, it's great. Extremist and foreign sites are blocked automatically. Scenes of violence are also recognized by AI and at least are hidden from audience under 18 or under 21 in other countries. But here is the thing, the very important thing. Sometimes the AI is wrong, and cruelly so. On November 27th, 2020, last year, Bloomberg published a grieving article under the headline, "Small Business Loses Sales as Software Blocks Advertising Accounts." So the account of the seller of seeds was blocked after the photo of onion was considered openly sexual. I think that's because onion is the same color as human skin. That's why. But AI is wrong, you see. The article provides another example about the blocking of account of New York businesswoman Ruth Harrigan, a seller of honey and beeswax in souvenir shops. On November 11th, just ahead of Black Friday, Facebook blocked her Honeygrams account for violating its policy. And again, you see that honey and wax are colored as human's skin. Friends advertised Harrigan to wait a couple of days and the problem will resolve itself. She waited until she lost approximately $5,000 in income. My personal experience. Here you see this woman is my mom, and YouTube blocked a video of my mother and her colleague playing a piano ensemble on 2 grand pianos. I uploaded the video to my channel, set access by link, and immediately, few seconds after filming, I received a notification about copyright infringement. Of course, I immediately wrote to tech support, explaining who and what is playing, and that is general. This video is necessary for my mother for the contest, and I helped her. They unlocked it during the day, but this is just a personal video for the contest, for my mom's contest? And how much does business lose due to the blocking of the system? According to Bloomberg, Facebook's human moderators in 2020, in last year, were focused on elections and COVID-19 misinformation. So the company relied more on on AI, artificial intelligence algorithms, to monitor other areas of the platform. That's why The Onion was considered as openly sexual. And this had led to many small businesses being trapped by Facebook's automatic filters, unable to advertise through the service. And most unpleasant thing is that entrepreneurs do know why their accounts were blocked, and human moderates also doesn't know this, the reason of it. Why? Human supports write something unintelligible. For example, this system may have blocked you for so and so. And who knows the truth? No one knows for sure way. And human moderator says the same things. No one knows for sure. The most difficult thing in such cases to prove losses or damages. I have some ideas on how to make a case and try to sue Facebook for lost profits, but suing Facebook over advertising isn't as easy as it sounds. Most of these cases go by headlines, fake news. You can see one of the article of last year, 2020. Often it's just a hype, secret agreements, the terms of which we will never know. Here is only one example. So Crystal Oretta, a Philadelphian tattoo artist, acquired nearly 1 million fans and followers on social media platforms Facebook and Instagram. Her followings is thanks in large part to her inspiring story of weight loss. She shed more than 120 pounds and 14 dress sizes. It's extremely inspiring. So she posted numerous before and after photos in order to document her achievements and in hopes of inspiring others. Then the photos Areta used to share her story began popping up on Facebook and Instagram as part of an illegitimate weight loss product of advertisement campaign. In June 2018, Areta filed suit against the social media giants, seeking monetary damages and an injunction to stop their alleged knowing approval of advertisements that used her images, name, likeness, and trademarks without her consent. Areta claimed her social media followers, eager for dieting solutions and tips on losing weight, clicked on the illegitimate ads because they were under the impression that Areta had sponsored or endorsed them. She believed the ads was demeaning toward her and harmful to her personal and professional reputation. We can speak more longer, but on November 6th, in 2018, an order was entered by the Federal District Court in Philadelphia dismissing the case due to settlement. And of course, the details of that settlement were not disclosed. And again, who knows? Remember, in the online space, we have the opportunity to complain about copyright infringement in almost all social networks. Oh, I should turn the next slide. And search engines. But it can be very difficult to prove that you are not violating copyright. And few more cases for you. 50,000 for one photo. You can screen it, or I shall give the presentation to Eugenia, to our nowadays moderator, and you will look through them more carefully. So this is a case between photographer. His name is Dionys, and he has so difficult full name, Francois G. Dionys. He's a French photographer, and he claimed against Zara. Zara is Zarifa Pashaevna Mgoyan, and she lives here in St. Petersburg. That's why the case was decided by Petrogradsky District Court of St. Petersburg. So Dionys took Zara's pictures for a famous magazine called Cosmopolitan, and then Zara took one of perfect pictures of herself and used it in her advertising, on her YouTube channel, in her Instagram, and so on. And Dionys did not give his permission to publish his photo in so many places, and he took to the court and asked more than 1,006,100 rubles and moral compensation. Not bad, right? The court, of course, was more humane to the singer, and the compensation was only 250,000 rubles. Then online course protection, a positive court decision almost a year after the discovery of the theft of the course. These entrepreneurs didn't want to go to the court because, as I said above, it's very long and it's quite hard to get the money back. But if you don't try to save your courses, you can lose even more money. So it's the case of last year. Krasnoselsky District Court of St. Petersburg issued a decision on the claim of Paris Nails for the protection of inclusive rights to the result of intellectual activity, recovery of damage to one woman who spread the course, the Paris Nails courses with the help of WhatsApp Messenger. So 5 100,000 rubles in favor of the plaintiffs as the compensation for damages. Then, one more interesting brand dispute. From May to September 2020, the Russian Patent Office considered the application of Volkswagen, which wanted to cancel the legal protection of the trademark of the fashion clothing Vola wear, which the showman Pavel Vola has been producing since 2019. What do you think? Are they similar? I think not even. The Vola's brand is not revoked. Then some more cases. How much does the song by Olga Buzova cost? You can see the sums of money. Archer Music Productions is her production center, and it really won a number of suits against beer halls and restaurants for illegal use of tracks. For each of 116,000 rubles, you see. But there was another case. DJ Tivoli wins more than 500,000 rubles over the fragments of his compositions in song Were Not by Olga Buzova and Nastya Kudry. You see as well, here are some more cases. You have already screened, I think, or you will read this presentation then. And one more case, the case of the right to a concert program. In autumn 2020, repeated decision on the claim of Belta Zadornova. It's not the first claim. You see that it's repeated decision. She went 3 instances, and then the High Court, the judge, the Court on Intellectual Rights returned it for the first instance, and its repeated decision to first channel for violation of the exclusive right to the concert problem by Mikhail Zadornov, and the court ordered to pay more than 3 million rubles as a compensation for violation of the exclusive right. So, conclusions. Oh, it's almost an hour. I'm shocked. Copyright is the online space. In the online space is everywhere. Don't violate yourself. Don't let us violate your. Don't let them. It's a mistake. Violate your own. You can protect your copyright, and I should say it for every one entrepreneur. You can protect your copyright. Don't think that it's very, very difficult. Yes, it takes time. Yes, it takes money, but you can lose more money if you don't protect your copyright. And we need to act. We need to act together. Thank you so much.
Thanks, Emilian, Elena. We have a question in chat.
It was Alexander. Is this nice picture in your slide copyrighted?
Yeah, the picture with onions, which look extremely sexual. So
I think it's nice. It's not my picture.
Okay, the question is, for example, using the illustrations for presentations.
Creative Commons 0.
Okay. So I have a question. Thank you very much. Just many thanks from me personally. Thank you for giving some examples of balance. We are talking about, for example, Olga Buzova. She files claims. She also gets some suits. So the balance is somewhere here still. So my question is about social net ВКонтакте, which is very popular nowadays in Russia. You told us about Facebook cases, YouTube cases. What about ВКонтакте? Have you had any cases? Do you think their artificial intelligence works?
There are much more human moderators, and we had last year we cooperated with Evgenia Oleynikova. She is the head of moderators, and she told that they only follow Russian law on advertisement, neither more, and it's they have some rules, the inner rules, but they don't opposite that law.
So
it's easier
is Russian
to advertise in ВКонтакте. It's much easier. And we can claim, you can see there, we can claim on violence of cooperating.
Okay, and maybe just a couple of words for people who are maybe startups or whatever, just your potential clients, which are thinking to launch some advertising campaign. So what should they check before they start?
Don't breathe and make a cross for your ad creatives when you post them. So what should they do? They should only read the instructions, read the rules of Facebook's ads companies, and you will see that it's prohibited by Facebook to advertise, for example, profession and point sums of money which can be earned there. So you can't advertise
vacancy. Your vacancy. Yeah?
No vacancies when they teach a profitable profession, for example, constructor of sites, and learn how to construct sites and it's money from your employer, yes, and
your profit will be
make money, yes, make money, and from 100,000 rubles, for example, it's prohibited. There are many strict rules, but if you read with your eyes, with the help of your eyes, you won't violate some of them.
Thank you. So we have the option to turn on your sound. So please feel free to write questions in the chat or just to ask, because the aim again of our IP Legal English Speaking Club is also to practice English, not in writing and in oral as well. So we really do welcome.
And if you have no questions, so give marks from 0 to 10. It is very important to me to have your marks.
Yeah, it's very nice for a speaker to have a feedback on the presentation. So it's really a challenge, of course. Elena, we will ask, yes, to get your presentation so that we can distribute it to everyone who wants to get it. I will write our email address just for communication if someone wants to ask something or whatever.
Елена, good day. Can I ask you one question, please? Can you suggest for our guests, guests of our forum, some ways to protect protect the copyrights in internet? What is best way, or maybe few of them, what the author should do to protect his right? Excuse me, my English. Yeah. Do you understand my question?
Yes, clearly. It's a more philosophical question. So there are some technical programs, for example, Info Protector, and with the help of them, you can protect your copyright from technical side. And what can we do as lawyers? We can do contracts, and contracts in which we don't write all problems are solved under the legislation of Russian Federation. No, we write there concrete fees, concrete fines for breaking the articles of that contracts. And why does this question is quite philosophical? If you want to protect, for example, your bicycle, what will you do? Even if you make lock with a chain, if somebody wants to steal your bicycle, he will cut the chain and ride on your bicycle. And when we talk about your courses, your text, your pictures, any objects, so who wants to steal them, he will steal anyway.
Thank you, but I am not agree with you, because the question was what the way to protect previous protection, what the author can do. For example, he can go to the post, yeah,
you say about
or maybe he can go to notar office, or maybe he can go, or sorry, he can download to internet database for such cases, yeah, like VPO, yeah. What do you think? What is best?
I think the best proof is the proof of the evolution of ideas. So we have, of course,
Depositing, yes.
Yes, depositing. We have notary, and we can go to the post, even send an email to ourselves with our text or pictures, but the proof of evolution of your ideas is the best. If I will deposit your text, your book, your in any object, your work, your author work, will I be the author of this work? Not even. And the High Court said that the depositing is not Not
Not a confirmation of authorship.
indisputably a proof. So the only one is proof of evolution ideas.
What do you mean by evolution of ideas? You mean the documented step-by-step creation?
I mean, when I wrote my book, my 6th book this year, I very hope it will be edited by Phoenix. We're trying to publish it for more a year. I wrote it a year ago. So I wrote one chapter and I saved and I wrote my book 1st of March. Then I wrote next piece and I don't save in the file by the same name. Resave by the other name. My book is on 2nd of March, and then the next day, 3rd of March, and you will see how my idea was evolving. And if you have some pieces, if you have some drafts, if you have raw files, then which then you improve, that's the proof of evolution of your ideas, of evolution of your work.
But how to?
Thank you.
Yeah,
Thank you.
sorry. Yeah, how to prove that the date of this file is what is written in the file, but not you illegally changed this date afterwards? So how to prove the correctness of the date?
At first, there are experts who can help in solving these problems, and you can buy the newspaper, or you can make a screenshot with the news, and it will be the date. It's easier. I don't hear you.
Yeah, thank you. Good idea.
Yeah, excuse me, can you repeat again, please? You suggest to make a photo? I don't understand.
So, okay, another case. My son wrote, found a method. His teacher said that it's a theorem. Господи.
Theory, yeah.
Theorem, так и есть.
Theory, yeah. Okay.
Theorem. And to what Alexander asked, to prove the date, we bought a newspaper and we made a photo where there is a newspaper and his theorem, and that is the date. And if you do something in internet, it's very easy to find the date, because all your posts, all your digital footprints, they are numbered by dates. And if you will make a screenshot and put it in your file when you wrote, for example, your book, it will be a proof.
So, in other words,
Thank you.
just upload it somewhere in the internet, and then you could prove the date from the cloud or something else or social network where this was uploaded, this date. Yes?
Yes, yes, yes. In the internet, you have an objective reasons or objective dates, and it's not necessary to do something more.
I would also like to add just using web archive, web archive. Yeah? So if something was deposited on the website, so usually there is a digital, footprint, so trace this special service, webarchive.com, if I'm not mistaken, and you can use it, and the court usually accepts it as a proof. Yeah. Okay, interesting questions. Very practical questions, actually. And I've also seen this situation, for example, for the United States of America, as you may know, when you register a trademark, you have to prove the usage of this trademark every 5 years. And to prove, for example, that your trademark is being used for this specific date, for example, the 27th of April of 2021, you can, buy a newspaper and make a photo with a newspaper, and it is considered to be kind of a proof for this specific date. Yep. Okay, Elena, my very big thanks. I know that it's a real challenge for a person throughout this complicated COVID time, when we don't travel a lot, we don't have so much practice of English as we maybe usually have, to speak English for such a long period of time in this specific area. I know that you are expert in this area, but still, speaking English is a challenge for us. And thank you again.
Very big challenge.
Once again, we still have people joining us, so I think.
Yeah, Evgenia, can I say also some words, please? Yeah, Elena, I'm very grateful to you for joining our forum and for your presentation. And you are welcome to participate in our follow events in IP field. And I hope that we will collaborate in the future. And I congratulate you with International IP Day. Thank you very much. And congratulations to all, to everyone who participate in this round table. We call this not a round table, Evgenia, but it's our meeting of IP Legal English Speaking Club. Thank you very much, Elena. Thank you.
Thank you very much. It's a high level of your foundation, and it's a big responsibility for me. Oh, I don't know what to say, but I love you so much, and I'm very grateful to you. And it's cool that we now we know each other. Great. Big hugs.
Yeah, thank you very much. Unfortunately, I cannot switch now my camera. Yeah, but I would like to say some words, because this year we make this event very quickly. But I'm sure that next year and following years, we will do our best to organize full English-speaking conferences on different items. Yeah, and I hope that you will participate in this conferences, because I think it is very important to be able to speak on English on IP topics, on IP Teams, I don't know, excuse me. Yeah, and this is one part of my dream, yeah, to make our IP society more open to the world. And today in the morning, when we have first our event with our Indian colleagues, we already have two of them as our members. We invite them, and honestly, we not invite, they already ask, they joined our club, and we already have 2 more members in our club from
And
India.
Can I join to your club too?
Sure.
Yes, you are welcome, and everyone most welcome. And I'm very grateful to Evgenia to lead this project, for leading this project. I know that my English is not so very good now, but I will look to, I hear your presentation, and I promise to next year I will improve my English, and I hope I also can speak very fluently. Because, yeah, thank you very much for your participation, for your collaboration. I wish you a very good achievement in your profession, and please be in touch. Thank you.
Thank you so much.
Thank
Okay.
you. Thanks.
I would also like to welcome you and to invite everyone, because almost in an hour at 1 p.m. Moscow time, we're going to have our next meeting of IP Legal English Speaking Club with Alexander Privin, Doctor of Science, which will be devoted to patenting new materials worldwide. And at 4 p.m. we will have next stage of our Legal English Speaking Club. Nadia Regent will talk about international IP protection for small and medium enterprises. So please stay tuned with us, and hope to see you in about 40 minutes online here on this, using the same link.
Okay.
Okay. See you later. So we
See you.
We are closing for now, but we will start the conference in half an hour. Okay.
Yeah.
Thank you. Thank you very much. Thanks.